Lesson: the role of arbitration in employment disputes. Arbitration has become an increasingly significant mechanism for resolving employment disputes. It provides a forum for addressing conflicts outside the traditional court system, offering an opportunity for more expedient, cost-effective, and confidential resolution. To effectively manage workplace disputes, HR leaders must understand the role of arbitration and how it can be leveraged as a tool to both prevent and resolve conflicts within the organization. Arbitration differs from litigation in that it involves a private process where the parties agree to have a neutral third party, the arbitrator, make a binding decision on the dispute. This process is governed by the principles of fairness, efficiency, and finality, providing a streamlined approach to conflict resolution. One of the core advantages of arbitration is its flexibility. Parties can tailor the process to suit their needs, from selecting an arbitrator with specific expertise to setting timelines and procedural rules. This flexibility is particularly beneficial in employment disputes, where the nuances of workplace dynamics, industry standards, and employment law intersect. The effectiveness of arbitration in employment disputes is evidenced by its adoption in various sectors. According to a study by the Economic Policy Institute, over 55% of non-union private sector employees in the United States were subject to mandatory arbitration agreements as of 2018. This widespread use underscores the perceived benefits of arbitration, including reduced legal costs and faster resolution times compared to traditional court proceedings. For HR professionals, understanding the arbitration process is crucial for ensuring that disputes are managed effectively. The first step in leveraging arbitration is the drafting of a clear and comprehensive arbitration agreement. This agreement should specify the scope of disputes subject to arbitration, the rules governing the arbitration process, and the method for selecting an arbitrator. A well-drafted agreement can prevent ambiguities that may lead to further disputes, thus serving as a proactive tool in dispute management. Once an agreement is in place, the next step is the selection of an arbitrator. The chosen arbitrator should possess not only expertise in employment law, but also an understanding of the specific industry and organizational context. This expertise ensures that the arbitrator is equipped to make informed decisions that consider both legal standards and industry practices. HR leaders can establish a panel of pre-vetted arbitrators to expedite the selection process, ensuring that suitable candidates are readily available when disputes arise. With the arbitrator selected, the arbitration process can commence. A practical tool for managing this process is the establishment of a framework for pre-arbitration procedures. This framework should include guidelines for the exchange of information, timelines for submission of evidence, and protocols for pre-hearing conferences. These procedures help streamline the arbitration process, reducing the potential for delays and ensuring that both parties are adequately prepared for the hearing. A key component of arbitration is the hearing itself, where evidence is presented and arguments are made. Unlike court proceedings, arbitration hearings are typically less formal, allowing for a more conversational and collaborative atmosphere. This setting can facilitate a more thorough exploration of the issues at hand, promoting a deeper understanding of the underlying causes of the dispute. HR professionals can play a vital role in preparing their organizations for arbitration hearings by ensuring that all relevant documentation is organized and accessible, witnesses are briefed and prepared, and the arguments presented align with organizational policies and values. Following the hearing, the arbitrator will issue an award, which is typically binding and enforceable in court. The enforceability of arbitration awards is one of the primary advantages of arbitration, providing a level of certainty and closure that is often lacking in other forms of dispute resolution. However, it is essential for HR leaders to understand that arbitration awards are generally final, with limited grounds for appeal. This finality underscores the importance of thorough preparation and effective advocacy during the arbitration process. In addition to resolving disputes, arbitration can also serve as a preventive measure by fostering a culture of open communication and collaboration within the organization. By adopting a proactive approach to dispute resolution, HR leaders can use arbitration as part of a broader strategy to enhance workplace relations and reduce the incidence of conflicts. This strategy may include regular training sessions on conflict resolution, the establishment of clear communication channels, and the promotion of a workplace culture that values diversity and inclusion. Case studies further illustrate the practical application of arbitration in employment disputes. For example, in a dispute between a major retail company and its employees over wage and hour claims, arbitration allowed the parties to resolve the conflict in a fraction of the time it would have taken in court. The arbitrator, with expertise in employment law and retail operations, facilitated a settlement that addressed the employees' concerns while allowing the company to continue its operations without disruption. This case demonstrates how arbitration can be an effective tool for balancing the interests of both employers and employees, leading to mutually beneficial outcomes. Statistics from the American Arbitration Association indicate that arbitration can significantly reduce the time and cost associated with resolving employment disputes. On average, cases resolved through arbitration take approximately 8 months compared to 24 months in court, with costs typically reduced by 50%. These figures highlight the efficiency and cost-effectiveness of arbitration, making it an attractive option for organizations looking to manage disputes proactively. HR leaders must also be aware of the challenges associated with arbitration, such as the potential for power imbalances between employers and employees. To address this, organizations can implement measures to ensure that arbitration agreements are fair and equitable, such as providing employees with the opportunity to seek independent legal advice before signing an agreement. Additionally, HR professionals can advocate for the inclusion of clauses that allow for the review of arbitration awards in cases of manifest injustice, providing an additional layer of protection for employees. In conclusion, arbitration plays a crucial role in managing employment disputes, offering a flexible, efficient, and cost-effective alternative to traditional litigation. By understanding the arbitration process and implementing practical tools and frameworks, HR leaders can enhance their proficiency in dispute resolution, fostering a workplace environment that values collaboration and open communication. As organizations continue to navigate the complexities of employment law, arbitration will remain an essential tool in the HR leader's toolkit, providing a pathway to resolving conflicts and promoting organizational harmony.